The first matter to come before us this morning is in re KT, KT, and KT. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning and can keep you apprised of the passage of time. The court's read the briefs and we are ready to see when you are.
May it please the court, I'm Attorney Denise Ferguson, and I'm here on behalf of appellant Mark A. Thomas, or maybe it's Mark Thomas, I'm not quite sure how he pronounces it. I apologize for that. I would like to reserve 5 minutes for rebuttal. I know you've read the briefs. I would like to start talking, however, about whether or not my client is duly represented. I am well aware, as this court is well aware, that a parent that is incarcerated does not have to be transported, provided, according to case law, that a few things happen. The first thing is that they have to be represented by counsel. There has to be a full record of the testimony or proceedings made, and the testimony that the parent may wish to present could be offered by way of deposition. This case differs from other cases where a parent is incarcerated because my client's trial counsel was not present during the entire hearing. While it may have only been a few minutes or a few pages of testimony that she was not there, he did not receive any representation during that period of time. And the court did not wait for trial counsel to show. They began the...
I apologize.
That's
Well,
okay.
I had this off.
Electronics tend to do that.
Yes.
Trial counsel had apprised the court they were going to be running a few minutes late. The trial court did not wait for trial counsel to get there. Instead, they allowed the trial to proceed without her, and the first witness was called, who was the caseworker. As such, father was unrepresented. He had also written letters asking to be transported. I am well aware that that right is not an absolute right for a parent. However, trial counsel was ineffective in not requesting that father be transported, nor were they ineffective by not showing up on time for the trial, leaving my client without any representation when his children were at stake. And again, we all know that a permanent custody trial is the death penalty of family law cases and juvenile cases. Another error that I believe happened was, rather than granting permanent custody, this court, or the trial court, should have not granted it and allowed great-grandmother a chance to have custody. Great-grandmother testified that she had contacted the agency as soon as she found out that these children were her children. When this case started, paternity had not yet been established. Great-grandmother started calling in December, right after she found out that the children were hers, or her great-grandchildren. She called back in January. No one called her back. That is an issue. She was not given a chance to have a home study at that point, or for anyone to evaluate her home, her background, or to see if it was appropriate for her to get custody of the children and thus preserve father and mother's parental rights.
Hadn't she been offered the opportunity to have kinship care of those children prior to December, though?
Well, she had been offered at the beginning of the case. However, at that point in time, she was not aware if they were her grandchildren at all.
Had she never had any contact with those children prior to the initiation of this agency taking custody, temporary custody at that time?
I am not sure of that, Your Honor, and I apologize. I did not see any mention of that in the transcript, so I am unaware.
But you say she did not know that she had grandchildren.
She did not know that they were her great-grandchildren. And
So what was her belief as to any kinship between herself and the 3 children?
based on what I found in the record, what her belief was that she knew these children existed. Her grandson was going to have a paternity test to determine whether or not they were his children. He did that while incarcerated, sometime between August and November. The results came back, and that's when she found out. That is what the record states from what I found. Another issue was that grandmother testified, or the juvenile court found that great-grandmother would need the assistance of family to care for the children. What the actual testimony was, though, was not that great-grandmother would definitely need the assistance of family, but that she might need some help due to some other circumstances that might occur. It wasn't a definite, it was very nebulous. And that could have been anything from child care assistance or monetary. It was never expressed. She did state she would not need assistance to watch the children on a day-to-day basis, however. And her family would be there to help her if she did require anything. So she had a support system. She had a home that was paid for with no mortgage on it. She had 3 bedrooms in this home, and she described the home as appropriate. The guardian only went out that day to see her house, or the day her report was due, and she was only there for a half hour to 40 minutes. And her report was filed about 2 hours later, so there wasn't really a lot of investigation done by the guardian at that point. And the caseworker and the agency did not fully evaluate her either because they didn't call her back several times. They also found that my client was unwilling to support his children and had abandoned them because he had not been in contact or supported them since August of 2013. Well, in August of 2013 through March, he was incarcerated. While the state says that that shows he is unwilling to support his children, he could have written letters or such. The youngest child was born in 2013, per the record. The youngest child couldn't read, couldn't talk, couldn't do anything.
She's not, that child's not part of this case, though, is she?
Yes, KT 1, 2, and 3. KT 3, and I hate to refer to them by numerals, but KT 3 is part of this case. All 3 KTs are.
And he did have, between May when the case was filed and August when he went to jail to go get the paternity test done. So he did have 5 months where he could have gone and gotten the paternity test done and established paternity for these kids.
I concur. He was visiting, however, and he was establishing a bond with them. He acted appropriately during the visits. So he was having communication with them before he went to jail. Why the paternity test was not done earlier, I do not know.
With respect to that issue of abandonment, in reading the court's entry, I see that the court has said that the mother has abandoned it, but I don't think they made a specific abandonment finding under the statute as it relates to father. That the actual finding was related to other sections of the statute and not specifically abandonment. Is that not your understanding of the result here?
In reading some portions of the entry, it struck me that they found that he had abandoned. There was one section of the entry.
At the beginning, but that section includes both mom and dad. That threw me for a little confusion at the first go through also.
Yes.
But I guess the question to you is do you perceive the order as a whole as making a finding of abandonment under the statute as it relates to father?
On my reading of it, it seemed to, because they did state that he had abandoned the children, as had mother. And then later on, it seemed to refer back to that and say he had not communicated with them and he was unwilling to provide for them. So in reading it in juxtaposition with everything and as a whole, that was my interpretation of what the court was saying. Furthermore, one of the issues also was that mother and father were given very short amount of time. More so mother, because mother still had the opportunity to finish, but within 9 months the agency filed for permanent custody. They didn't get a reasonable bypass. There was no reason why they couldn't have allowed mother and father a little bit more time, and even taken a little more time to explore relatives that had come forward. If they would have given parents the full 12 months, the children may still be part of the Thomas family. And by Thomas family, I mean in the great-grandmother's care or some other relative's care, if they weren't going to give the children back to mom. My client could not take custody at that point, but relatives were definitely an alternative. And there was.
So you're just now reaching your 5 minutes rebuttal, you can continue or preserve as you wish.
I will preserve at this point then. Thank you.
Good morning. May it please the court, my name is Erin Davis. I'm with the Lorain County Prosecutor's Office, representing Lorain County Children's Services. With regards to this case, with regards to the first point in which the appellant pointed out of the ineffective legal counsel of this trial attorney. This trial attorney was not there for the first 9 pages of the transcript. Within the caseworker's testimony upon that time, there was only testimony with regards to the previous facts found in the adjudication disposition, in which she was present at all hearings for the adjudication and dispositions of all children. This second part of this trial as well was she was present for the 9 a.m. portion of the trial. At that point, mother did not appear. The court did determine that the trial court would come back at 1:30 to start the trial to see if we could find mother. And during that time, the caseworker did go on the stand. However, all of the facts presented during that time until the trial attorney entered the room were facts with regards to the adjudication, disposition, entry, and the facts within. She was present for the other 200 pages of transcript. Not only was she present for those 200 pages of transcript, she cross-examined the caseworker extensively with regards to father, with regards to his incarceration, and she also presented her own witnesses, which was paternal great-grandmother. The trial attorney was not ineffective during this time. She was present, there was a full record, and with regards to the non-transportation of the father to the trial court, father is unable to show that the outcome of this trial would have been different if he was present. The father, with regards to the elements in which the trial court found, father would not be able to show that he substantially remedied the conditions at the time he was still incarcerated. He would not be able to demonstrate that he showed commitment towards these children during his incarceration, and he would not be able to show that he was not incarcerated at the time of the PC filing. The filing was done approximately 9 months after the first adjudication disposition, but Children's Services was involved for quite some time prior to the initial adjudication disposition of 1KT and 2KT. With regards to paternal great-grandmother was contacted from the very beginning. The 2 oldest children were placed in Blessing Home, which is a short-term respite care in Lorain County. Paternal great-grandmother was present at the hospital when the oldest 2 children were born. There was a determination on the older 2 children earlier in the case. It's the 3rd child that paternity was not established right away. Paternal great-grandmother refused to take these children and the 2 oldest children, and rather they were put in Blessing House. The caseworker testified that she consistently tried to get paternal great-grandmother to care for these children. These children were in foster care for the oldest 2 children were in foster care for 9 months. The youngest child was in foster care for approximately 7 months. And paternal great-grandmother did not appear at any time during that time until the PC motion was filed. Even in January of 2014, the appellee does dispute whether or not those phone calls have been returned and so forth, and that was in the transcript that the phone calls were not returned or returned. There was different stories of whether or not those phone calls were returned. However, grandmother never made a commitment to these children that she would take them in and take them out of foster placement. And although she says that paternity was not established and that was her reasoning, God bless you, that was her reasoning, there was a lot of trying from Lorain County Children's Services to find a relative. With regards to father being committed, whether or not Lorain County Children's Services waited 9 months, 10 months, 11 months, or 12 months, that father was still going to be incarcerated. It would be futile to wait any longer for these children.
Had father been involved, you mentioned that prior to this case being filed, the agency had had contact or had something going with mom and these children prior to this. Was dad involved in any of this at that time?
Yes, Your Honor. Before the father went to prison in August of 2013, he was involved and he did come to all the adjudication.
In this case, but you had
Yes.
mentioned that before filing this case, the agency had been involved with the family.
Correct. The agency was involved prior to filing, yes. In court, yes. And father had always been present. Father was present within this case until he went to prison in August of 2000.
But I'm asking, before you filed this case, I thought I heard you say that the agency had extensive contact with the family before you filed for this case.
It's my understanding, yes, Your Honor.
Okay, is there any record that father had anything to do with these children prior to the agency filing this case?
I do believe, yes, Your Honor, he's always been present for the birth of the children. I don't think he's ever denied that he was the father. There was no dispute that he was the father from the very beginning of this case. Whether or not Children's Services had yet filed in court. I do not believe that was ever an issue of whether or not he was the father of these children. I don't know if the birth certificate or some type of legal document was done at the hospital and that's why paternity had to be established. But it is my understanding from the transcript that paternal grandmother did testify that she was even present at the birth of these children. The presence of father was never an issue of whether or not he denied these children.
Was he involved in their lives on a day-to-day basis prior to this case being filed?
I do believe so, Your Honor, yes, as I do believe he was living with mother at that time. And he did appear for all court hearings prior to him entering jail of August of 2013, in prison of 2013. Even before he went to prison, there was testimony from the caseworker that although present, he was not making any case plan progress. The caseworker did set out a case plan for father with regards to the objectives to be met. She tried to work with mother and father, and then after being admitted into prison in August of 2013, father, although Lorain County Children's Services continued contact with him in letters, father did not make any progress on his case plan, and he did not write any letters to the children. He did not communicate with the children whatsoever. So I believe that there will be.
What is customary when a parent is incarcerated? You say he didn't make any progress on his case plan. Well, there are certain limitations that he couldn't make some progress. So what reasonably was expected of him while he was in prison, and did he live up to those measures?
I do believe that the caseworker, there were some services set in place in prison with regards to mental health services. I'm not quite sure whether or not he was fully committed in following through with the limited services that they were able to provide in prison. Obviously, he cannot get the help with regards to housing once he's out of prison and employment and basic needs for these children once he's in prison. But I do believe that there was some services trying to be set in place for his mental health concerns and any other drug and alcohol issues that may have been present. So I do believe that they tried to work with father in those regards in the limited capacity that Lorain County Children's Services was able to do so.
What about visitations?
Was
that possible, or?
I do not know if that was possible or not, Your Honor.
Is there anything in the case plan after his term or before of incarceration regarding maintaining contact with the children in one form or the other? Actually, in the case plan?
Yes, within the case plan prior to him going to jail in August of 2013, there was visitation. There was visitation once a week. It's my understanding that he was visiting with the children. What I believe prior to him going to jail that he was not completing were the mental health services and the other services, and the other objectives. I do believe he was visiting with the children prior to that. After he was incarcerated in 2013, I do not believe that visitation was able to be held at the prison. There would have to be transportation between the foster parents and children's services and the prison itself. So I'm not quite clear whether or not there was even the opportunity to have visitation at that time.
Is there any requirement that a person with the agency transport children to a prison to visit an incarcerated parent?
I am not quite clear on that, Your Honor. I'm not sure. So with regards to these children need permanency. Their mother and father both failed to complete their case plan within a reasonable amount of time. Lorain County Children's Services did the reasonable efforts that were necessary in this case. They don't have to do every reasonable effort possible, but what is within the what is reasonable at that time. And they did everything that they could with both of these parents during that time. Waiting any longer would have been futile and would have put off the permanency needed for these children to be adopted and move on and to have permanency within their life. So the Lorain County Children's Services would ask for the trial court decision to be upheld at this time. Thank you.
Your Honor, one of you asked me regarding, I believe it was you, Judge Hensel, you asked regarding whether or not father had been found to abandon the children. I did find that on page A7 of the appendix, if you look at number 10, it says, mother has not abandoned the children. Father has abandoned the children due to incarceration. So I wanted to clarify that point. To address some of the things opposing counsel has stated, father was involved with these children. That shows that he had not abandoned the children prior to going to prison. There was no visitation arranged, as opposing counsel has stated. Therefore, there was no way for father to actually see these children if no one took the children to him. Another point is, opposing counsel, she stated that trial counsel was not ineffective, and the reasons why. One of the arguments they made in their brief was that trial, it's not ineffective to do something that is futile. That was one of the arguments that was made. And therefore, she did not have to ask to transport. There was no reason that transporting dad for the trial would have been futile. It may have been denied, but being denied is not the same as being a futile exercise.
He'd been denied earlier though, right?
Had been denied earlier, but that was for a review hearing or another type of hearing that does not have the outcome of a permanent custody hearing. I mean, those are two very different hearings, earlier in the case or later. And I'm going to guess it was either a pretrial or a review hearing. It was never made very clear, but dad was present at adjudication disposition in the beginning of the case, so it had to be something of that nature, which is a minor hearing in the great scheme of things. So denying for a minor hearing is not the same as denying for the death penalty phase, so to speak. Opposing counsel also stated that the testimony of the caseworker, trial counsel, was therefore and cross-examined, and that only went into the very beginning of the case, and it only dealt with introductory material, so to speak. Well, father still was not present for that and still did not have counsel for that. And that seems to be putting, I guess, a hierarchy on evidence that opposing counsel believes is important and does not believe it's important. And there is no hierarchy in the law. And this court has stated various times that due process is extremely important for parents in this situation, and that the court must follow the law. And the law requires that a parent is guaranteed counsel if they're indigent at all stages of the proceedings, all stages, not just at major hearings, but at all stages. So not having counsel there just for introductory testimony doesn't comply with the law. It doesn't allow Dad that representation he is due. And that is pretty much all I have to say at this point, and I thank you for your time and for listening to me.
Thank you both, counsel, for your presentations today. Also, thank you very much for coming to Summit County to argue these cases. We greatly appreciate the effort that has been expended by counsel. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the House Supreme Court website. Thank you.